An update on law and legal system. Evolution of law. Law is a set of rules and regulations evolved from rule of nature to rule of man to rule of law. Primacy of law under rule of law. Equality before law, equal protection of law. Absence of arbitrary power, principles of natural justice, predominance of legal spirit, independent and impartial judiciary. Three types of law. Personal, covering Hindu Marriage Act, Hindu Adoption and Maintenance Act, Muslim Sharia Act. Public law or criminal law relating to government and society, includes constitutional law, administrative law and Indian Penal Code. Private law or civil law deals with relationship of individuals and organizations, covering rights of individuals, issues of mercantile or commercial nature. Sources of law. Three sources of law: customs, judicial precedents and legislation. A custom needs to be observed continuously for a long time without interruptions and has to be supported by general public and morality. The significance of custom as a source of law has reduced, particularly after independence. Second source of law, judicial precedent, refers to previously decided judgments of Supreme Court and High Court. This practice is adopted from English system. Judgments of Supreme Court are binding on all courts, but they do not bind Supreme Court itself. High Court decisions are binding on all courts within its jurisdiction. Lower courts follow decisions of High Court of their own state. Two variants of judicial precedent: ratio decidendi and obiter dicta. Ratio decidendi is the reason for the decision which is forming a part of the judgment. It is binding in future cases involving similar questions of law. But obiter dicta is an opinion expressed by the judge and it lacks legal conviction. It is relevant only as an illustration and has got only persuasive value for lower courts. Legislation, the third source of law based on enactments by states. Two variants: primary legislation and subordinate legislation. Primary legislation enacted by parliament or legislature, subject to constitutional provisions. Subordinate legislations made by local bodies and also include delegated legislation. Delegated legislations comprise rules, regulations, notices, etc. made by authorized subordinate executive. They are delegated due to technicalities, emergencies and need specialized skill evolved out of practical necessity. Normally, legislatures legislate on policy matters and executives make rules for their execution. Constitution of India. Features: quite modern, inspired by federalism of US and Canada, draws heavily from British constitutional law. Written constitution many unwritten conventions of British constitution reduced to writing. Preamble states sovereign, socialist, secular, democratic republic, aims to secure citizens justice, liberty, equality and fraternity. Aims at organizing India as a welfare state, strengthened by Directive Principles of State Policy (DPSP). is a union of states with the parliamentary form of government, vertical distribution and separation of powers between legislature, executive and judiciary. Independent judiciary with Supreme Court at the top, and judicial review, a basic feature of Indian Constitution. Fundamental rights. Fundamental rights contained in Article 12 to Article 35. Article 14, right to equality, equal treatment in equal circumstances. Case, Air India versus Nargis Mirza. Article 15, no discrimination to access public wells, tanks, places maintained out of public funds, but protection and advancement of women, SC, ST is an exemption. Article 16, equality of opportunity, subject to privileges to SC and ST for upliftment. Case, State of Kerala versus N.M. Thomas. Article 17, untouchability prohibited, contravention punishable. Article 18, not to use titles with name as a prefix or suffix. Exemption to military and academic titles. Article 19, Clause 1, right to freedom. Subclause A, freedom of speech and expression. Subclause B, freedom of assembly. Subclause C, freedom of association. Subclause D, freedom of movement. And subclause E, freedom of residence to settle. And subclause G, freedom of profession, occupation, trade or business. Subclause F has been deleted in 1978 as right to property is not a fundamental right anymore. Restrictions on right to freedom specified in Article 19, Clause 2, Subclause 1, sovereignty and integrity. 2, security of the state. 3, public order. 4, friendly relations with foreign state. 5, decency and morality. 6, defamation. 7, contempt of court. 8, incitement of offence. Restrictions to be reasonable and subject to judicial review. Case, Bijoy Emmanuel versus State of Kerala on singing of national anthem. Protection under Article 20 against ex post facto law. Protection against double jeopardy and self-incrimination. Article 21, protection on life and property. No deprivation except as per procedure established by law. Principle of natural justice. Case Olga Tellis versus Bombay Municipal Corporation. Right to livelihood is born out of right to life. Article 21A, free and compulsory education to be provided as per state law. Article 22, not to detain without informing grounds. Not to deny right to consult a legal practitioner. To be produced before a magistrate within 24 hours. And not to detain beyond 24 hours without authority of a magistrate. Article 23 prohibits begar, traffic in human beings for immoral purposes and forced labor of any kind. Case Bandhuva Mukti Morcha versus Union of India. Article 24 prohibits child labor. Sivakasi match industry is a classic case. Article 25, religious freedom, purely personal, covers rites and ceremonies associated with the religion. Article 26, gives freedom to manage religious affairs, the right not to conflict with the exercise of fundamental rights by others. Article 27 prohibits taxation to promote a religion. However, fee can be charged. Religious instructions prohibited in institutions of public nature. Study permitted, but imparting religious instructions prohibited. Article 29, right to conserve distinct language, script or culture, an absolute right, no reasonable restrictions. Article 30, linguistic or religious minorities can establish and administer educational institutions. Minority means less than 50% of numerical strength available for only citizens. Constitutional remedies under Article 32, Supreme Court to enforce fundamental rights. Even high courts have parallel powers under Article 226. Supreme Court to declare a law void if it is inconsistent with any fundamental right, and it can issue appropriate orders or directions or writs. Writs comprise habeas corpus, mandamus, prohibition, quo warranto and certiorari. Supreme Court is the protector and guarantor of the fundamental rights. Legislative process in India. Constitution is the primary source of law. Every law to be in line with secularism, socialism and democratic values. It should follow directive principles of state policy. Every law is preceded by a study on cost, benefit and challenges, which is prepared by the ministry, consulting interested or affected stakeholders, and a proposed resolution with explanatory note is kept on public domain for over 30 days. Ministry of Law and Justice vets the proposal from legal angle. Thereafter, it prepares the draft bill, which is sent for cabinet approval. After cabinet approval, suggestions of the cabinet are incorporated and the mother ministry prepares a statement of object and reason. The approved bill along with the statement of object and reason is then signed by the Ministry of Law and Justice. Article 110 specifies a money bill to be one involving imposition, abolition, remission, alteration or regulation of any tax, or involves borrowing of money by the union government or payment into or withdrawal from the Consolidated Fund of India or Contingency Fund of India. If any questions arises whether a bill is a money bill or not, the final decision will be that of the Speaker of Lok Sabha. Special procedure in respect of money bills specified in Article 109. A money bill shall not be introduced in Rajya Sabha. After it is passed in Lok Sabha, it shall be transmitted to Rajya Sabha. Rajya Sabha within 14 days shall return the bills to Lok Sabha with its recommendations. If Lok Sabha accepts any of the recommendations, the bill shall be deemed passed with amendments, or if the bill not returned within 14 days, the bill is deemed passed by both houses in the form in which it was passed originally by Lok Sabha without any of the amendments. Article 111 deals with assent to bills. When a bill which is duly passed by Lok Sabha and Rajya Sabha is sent to President, the President has an option to either assent or withhold his assent to the same. He may return the bill if it is not a money bill to the houses with a message to reconsider the bill or any of its provisions. The House, when it passes again with or without amendment and sends it back to President, the President is bound to assent to the bill. After the presidential assent, the Ministry of Law and Justice publishes the Act in the Gazette of India Extraordinary and forwards copies to all state governments for publication in their official gazette. Article 108 specifies the procedure of joint sitting in respect of a bill which is not a money bill. If after a bill has been passed by one of the houses and transmitted to the other, the bill is rejected by the other house, or the house has finally disagreed as to the amendments to be made in the bill, or more than 6 months have elapsed from the receipt of the bill by the other house, the President may notify his intention to summon a joint sitting for the purpose of deliberating and voting on the bill. At the joint sitting summoned by the President, the bill will be passed by a majority of total number of members of both houses present and voting, and the joint sitting is permitted even where the Lok Sabha is dissolved subsequent to the President notifying his intention to summon a joint sitting of the houses. Alternative Dispute Resolution or ADR. ADR involves resolving disputes through a mechanism which doesn't involve courts or litigations. It is a consensual process resolving differences involving a neutral third party. A decision reached in ADR may be binding or non-binding. Used in civil, commercial, industrial and family disputes. Advantage is it is simple, quick, flexible and accessible. ADR is envisaged by Section 89 of Civil Procedure Code, which permits courts to formulate terms of settlement obtaining observation of parties. The court can reform in terms of a possible settlement and refer it for arbitration, conciliation, mediation and judicial settlement, including through Lok Adalat, in which case the plaintiff will be entitled to receive refund of the original court fee paid in full. Arbitration involves appointment of an arbitrator who is an independent, neutral third person. He hears and considers merits of the dispute and renders a final and legally binding decision, which is called as award. There are limited rights of review and appeal of arbitration awards, and the proceedings and awards of arbitration are non-public and can be made quite confidential. The Arbitration and Conciliation Act 1996 lays down the procedure for arbitration and conciliation. Arbitration agreement can also be in the form of an arbitration clause in a contract. Before submitting the first statement in a suit, a party to arbitration agreement can apply to the judicial authority with a certified copy of the arbitration agreement, and under an arbitration agreement, parties decide the number of arbitrators, but not an even number, otherwise it can be a sole arbitrator. Unless agreed otherwise, when there are 3 arbitrators, each appoints one arbitrator. The 2 appointed arbitrators appoint the third, who shall act as presiding arbitrator. If there is a failure to appoint within 30 days of request, or third arbitrator not appointed within 30 days, the aggrieved party can request court to make the appointment. In case of sole arbitrator, failure to appoint within 30 days of request by one party, the party can approach court to appoint. Decision of the court shall be final and is not appealable. In a conciliation, parties to a dispute use the services of a trained, qualified, neutral person. Together, they isolate issues, develop options, and consider alternatives. They reach a consensual settlement that accommodates their requirement. Conciliation is not bound by rule of procedure and evidence, and conciliation does not result in a binding award. If conciliation proceedings fail, the parties can opt for arbitration. Under mediation, each party meets the expert neutral mediator. They describe the problem and the resolution they desire. Mediator is just a facilitator with the skill and experience necessary to assist. They will have separate and joint meetings to hammer out agreement of both parties. And here the parties want to control the outcome. The final agreement is that of the parties themselves. Section 89 of Civil Procedure Code provides for referring disputes to Lok Adalat. National Legal Services Authorities Act 1987 deals with Lok Adalat. It means People's Court and an effective alternative to litigation. It is a judicial institution for social justice. It is established by government for settlement by way of compromise or conciliation. It is usually presided by a retired judge or social activists or members of legal profession. Lok Adalats accept cases even pending within jurisdiction of regular courts, but they have no jurisdiction on matters related to non-compoundable offences. Award of Lok Adalat is enforced as a decree of civil court and is final and has no appeal. Legal terminology and maxims. Maxims are Latin words forming established principles of law. When used by courts in deciding cases, they have force of law. Ab initio means from the beginning. Actionable per se, the very act is punishable, no proof of damage is required. Actus reus, guilty act. Ad hoc, for the particular case on hand. Alibi, at another place, elsewhere. Amicus curiae, a friend of court. Audi alterum partem, no man shall be condemned unheard. Bona fide, in good faith. Corpus, body. Injuria sine damnum, legal injury caused without physical injury. Damnum sine injuria suffers physical injury with no violation of legal rights. De facto, in fact. De jure, by law. Doli incapax, child below 7 years of age incapable of crime. Ex gratia, as a favor. Ex officio, because of an office held. Ex parte, proceedings in the absence of the other party. Ex post facto, after the fact. Habeas corpus, a writ to have the body of the person brought in before the judge. Ignorantia juris non excusat, ignorance of law is no excuse. Ipso facto, by the mere fact. Impromptu, in readiness. In lieu of, instead of. Innuendo, spoken words that have double meaning. Status quo, in the present state. Inter alia, among other things. Jus in personam, right against a specific person. Jus in rem, right against the world at large. Jus, law or right. Locus standi, right to appear and be heard by court. Malafide, in bad faith. Mens rea, guilty mind. Misnomer, a wrong or inaccurate name. Modus operandi, mode of working. Mutatis mutandis, with respective differences having been considered. Onus probandi, burden of proof. Paripassu, ranking equally. Per se, by itself. Persona non grata, a person who is unwelcome or unacceptable. Prima facie, on the face of it. Q facit per alium facit per se, He who acts through another acts himself. Quid pro quo, something for something in return. Respondeat superior, let the master answer. Res ipsa loquitur, things speaks for itself. Sine die, indefinitely, with no day. Sine qua non, an essential condition. Suo motu, on its own motion. Uberime fidei, utmost good faith. Ubi jus ibi remedium, where there is a right, there is a remedy. Veto, ban order, not to allow something to become law. Vis major, act of God. Volenti non fit injuria, damage suffered by consent, gives no cause of action. Vox populi, voice of the people.